Good morning.
Good morning.
Morning.
Happy Monday. Nice to see everyone. We have three cases this morning, and welcome to the First District Court of Appeals. The first case that is going to be argued is In Re SD. It's cases number C200304, 05, 06, and 07. If counsel can please identify themselves and their readiness to proceed.
Jessica Moss, I'm ready to proceed.
Good morning.
Mary Steer for the state, ready to proceed.
Good morning.
Morning.
Attorney Moss, would you like to reserve some time?
Yes, Your Honor, I'd like to reserve 4 minutes.
4 minutes, all right. Whenever you're ready, we can start.
Good morning, Your Honors. May it please the court. My name is Jessica Moss, and I, along with my co-counsel, Robert Jones, represent the appellant SD in this matter. Now, SD suffered horrendous sexual abuse and trauma as a child at the hands of his biological parents. Prior to the charges in this case, SD had never received any treatment to address his past trauma and the urges he was having, as well as the fact that he had suffered from other delays. This history is paramount to the discussion of each of the assignments of error. Now, I'm going to discuss the assignments of error in reverse, starting with the third assignment of error. Here, the mandatory sentencing scheme in 2971.03 violated fundamental fairness and due process because it prohibited the sentencing court from making an individualized determination about an appropriate sentence, and it constituted cruel and unusual punishment because it did not consider youth as a mitigating factor before imposing a life sentence. Again, since due process and fundamental fairness require a juvenile court to make an individualized determination, that did not happen here. Last month, this court in Re DR found a statute unconstitutional and in violation of a defendant's procedural due process rights, since in an end of disposition hearing, the juvenile court had no other ability to decide an appropriate option other than continue the defendant's classification. For the same rationale that due process violation happened in that case, the same rationale applies here. As to the rate,
Let me ask you a quick question though. You are not making a procedural due process argument, are you? You specifically stated you're making a substantive due process argument in your brief.
That is correct. We are making a substantive due process argument.
And so DR was based on a procedural due process issue,
Yes,
right?
Your Honor. It
so
was.
How does it apply in this case?
So in this case, part of our argument did encompass the fact that an individualized determination has to be made as to youth as a mitigating factor. And in looking at that, in addition to the fact that the court was required to have this mandatory sentence, the same would apply here.
No, there was discretion. There was a level of discretion with the serious youth offender determination, right?
So there was a level of discretion in determining a serious youthful offender designation, but once the court decided to impose a designation, the court lost any discretion to determine what would be an appropriate sentence. The court was required, as to the rape charge, to impose the 15 years to life mandatory sentence. And that's where the discretion was lost by the juvenile court. So it did not matter that there was the ability to choose the SYO to begin with.
And how does that compare to the Patrick case?
So the Patrick case, even though that occurred in adult court, it specifically talked about at sentencing that there has to be a determination of youth as a mitigating factor at sentence. And in that case, the court did not make that determination.
Well, the court considered the youth because the juvenile was kept in the juvenile system. Patrick was a juvenile that was bound over, right?
That is correct. However, in this case, even though the juvenile court was required to consider youth as a mitigating factor, here the court looked at it as an aggravating factor. Specifically, the court looked at the fact that the court only had several years left before SD would turn 21 to work with him, rather than looking at youth as it was supposed to in terms of immaturity, and especially considering the fact that SD had other delays and hadn't received treatment for the issues that he was having in his past trauma. That would all go into looking at youth as a mitigating factor, not the amount of time that was left to work with him.
One of the one of the experts that testified talked about how it would take more time than what was had before SD would become an adult. In other words, there wasn't sufficient time to rehabilitate him in the time between then and the time that he would be an adult. And that was more than 3 years, I believe. What do we do with that?
Yes, Your Honor. So, and that goes into the second assignment of error. Now, the experts agreed that SD was amenable to treatment and was motivated to undergo treatment and to deal with the issues that he was having. Now, the experts talked about SD needing more than 2 years and about 2 to 3 years, which is the time that the juvenile court had left. It was never specifically that exactly 3 years was needed, because psychology is not an exact science.
But isn't that amenability analysis, didn't the court also employ that in the determination of imposing the serious youth offender status?
So in terms of the initial amenability determination, the juvenile court determined that the SD was amenable to treatment. Now, what's important is it going into the first assignment of error, the juvenile court had the ability, if it was concerned that SD would not be able to complete treatment within the 3 years and be rehabilitated within that time, continue the disposition out for up to 6 months to see how SD would do in treatment. And that is very important, again, considering he had never completed any type of treatment before for this extremely horrific abuse that he suffered as a child, or that these urges he was having. So the court could have seen how he was doing to say whether or not it would have been more likely that he could have actually completed treatment within that time. And that is why.
Doesn't the juvenile court have pretty wide discretion, though, to determine whether to impose the SYO designation?
The court does have the discretion to do that, but it has to be only as long as the juvenile could not be rehabilitated within the amount of time that the juvenile court had left. In the court looking at specific factors such as the history of the child, the nature of the charges, what services were specifically available to the juvenile through the juvenile system. And when looking at all of those factors, it can't be said that SD could not have completed treatment within that time. Additionally, the fact that SD would have been classified as a sexual offender and would have been monitored by the juvenile court for an extended period of time, even past his 21st birthday, would have gone to ensure that the court was able to monitor him, and it would have gone to protect the public and safety. And so all of the purposes of the juvenile disposition would have been met by doing that, and it wasn't necessary for the court to impose the SYO designation. In going back to the third assignment of error, in the mandatory nature of the mandatory sentence, here it's creating an irrevocable presumption that all juveniles are treated the same as adult counterparts when they are charged with the same type of offense.
But they're not really the same, right? I think life without parole is an option for adults, and it's not an option for juveniles, right?
Even though life without parole is not an option, the fact of the matter is that a life sentence, even with the possibility of parole, does include the possibility of a juvenile spending life in prison. And that is one of the factors that Patrick did look at, that it didn't matter that the possibility of parole was available, because that still went into the same Eighth Amendment cruel and unusual punishment concerns when youth as mitigating factor was not considered.
So he has the possibility of spending life in prison if he doesn't successfully rehabilitate while he's in front of the juvenile court, right? So the adult sentence is optional. It's like a stayed sentence.
It's a stayed sentence, but it was a mandatory sentence once the juvenile court decided to impose the SYO designation for the rape charge. Now, there were other reasonable alternative means of sentencing that already existed through the principles of the sentencing principles. And that is what the juvenile court should have been able to utilize rather than having to impose this mandatory sentence. In going to the third assignment of error, again, Criminal Rule 29 is different than Juvenile Rule 29, since Juvenile Rule 29 gives additional options. So beyond just asking for this to be continued out, SD had requested that the juvenile court either dismiss the charges or reduce the rape charge to an attempted rape. He was not asking for the importuning charges to be dismissed. And in doing so, that still would have been within the purposes of the juvenile court. In other cases, even after an adjudication has happened, have done the same thing of dismissing a charge when that served the best interest of the child and the community. Now, SD showed remorse for his actions, and there were significant mitigating factors that were all present in SD's case that weighed in favor of this dismissal of the rape charge while still holding him responsible and requiring him to undergo treatment. And dismissal of the rape charge would have allowed him to be rehabilitated without this term of rapist following him into adulthood without the ability of getting it sealed. For these reasons, SD requests that the court vacate the juvenile court decision and vacate the SYO sentence. Thank you.
Thank you. Good morning, Attorney Steer. Whenever you're ready.
Morning. May it please the court. I'll begin. Thought I lost you there for a second.
No, I had to plug in my computer. Slow.
I'll begin with the third assignment
Human
of error.
issues.
Please.
Human issues
Yeah.
or technology issues.
I'll begin with the third assignment of error. First of all, with respect to State v. Patrick, that falls within the cruel and unusual punishment argument. And I believe, as Mr. Havlin argued in the state's brief, really Patrick differs a lot from the situation here because, as Judge Krause said, Patrick was bound over as an adult. Here, SD stayed within the juvenile system. His age, consideration of his age permeates all the proceedings against him. His age was a factor all along. I mean, they talked about what had happened to him as a child, how he had progressed, his maturity level or his immaturity level.
Consideration of his age at the time of the offense or consideration of his age as he's before the court?
That both. I mean, it happened relatively quickly. I believe that he was charged in October of 2019. I think he was 17 and a half when he was charged. And so then he was 18 by the time disposition occurred. Mm-hmm. So it was always a factor. It permeates throughout. And part of it is because his experts said that they thought probably 3 years is what it was going to take to treat him. And so the fact that we were running up against that, I think the court was put in a position of trying to decide, beginning with the amenability hearing, whether or not to bind him over, or, obviously the court figured out or reasoned that if he went to adult court, he wasn't going to get the services that he could get in DYS. With respect to the due process argument, I agree that throughout SD's appellate brief, his argument is one of substantive due process, and the way that courts look at substantive due process is similar to equal rights arguments, and that looks to what kind of protection, first of all, the rights get. And unless it's a fundamental right, then we look at rational basis. And as long as the legislature had a rational basis, and here they have a rational basis for treating rape people who rape kids under the age of 10 differently. And so it survives a rational basis challenge. If we do move into the substantive if we do move into the procedural due process, and in looking at NRA DR, that was a procedural due process. And again, and as you said, I think Judge Krause, it was a question of whether or not there's discretion. And here the court obviously had discretion in deciding to impose the SYO, while the 15 years to life is a mandatory sentence for the rape of a child under 10. There was a possibility that if he had been an adult, and if he had been in adult court, he could have gotten life without parole. And also it's important to note that in 297103, E2, even if the juvenile defendant would violate, there's a hearing, again, it comes before the juvenile court, and the court still has the opportunity to modify the adult sentence that the court invokes. It can be for a lesser term or in lieu of the prison term if it wasn't mandatory, any community control. So there is a chance for the court to look at it and decide, even after a violation has occurred, whether or not the violation rises to a violation to invoke the SYO sentence, and then whether or not that's still going to be imposed. So the trial court does maintain, or the juvenile court does maintain some discretion over that.
And is this youth status considered in that hearing?
With the juvenile court, are you saying should he violate the?
Exactly.
I think, again, it would be just like everything else in juvenile court. I mean, that's what's considered all the time is the juvenile status and whether or not he's received treatment and how far, what else can be provided to him within the juvenile system. And if there's a possibility for something to be provided to him, services. Unless there's any other questions on that, I'll move to the other two assignments of error, which really are kind of wrapped up in each other because it's all a question of abuse of discretion. With respect to SD's juvenile rule 29 motion, obviously it was within the trial court or the juvenile court's discretion whether or not to grant it. And the state understands and acknowledges that SD had a horrible childhood himself growing up. However, also included within a decision under juvenile rule 29 is the best interest of the child and the community. And the whole point of the overriding purposes for disposition in juvenile court also looks at not only the public interest and safety, but also whether or not the victims have been restored. And I know throughout the appellant's brief, they say that the victims have been restored, but when you read through the disposition, especially the letter that was read for the four victims' mother, her letter was read by the prosecutor, the victims have not been restored. They're still suffering a great deal from this. So I don't think that rose to an abuse of discretion. And if I could just real quickly talk about some of the cases that are cited within there. A lot of the cases from the 8th District, INRE NI and INRE DR, none of those were talking about whether or not there was an abuse of discretion. Rather, it was a question of whether or not the state had the ability to appeal, and the state doesn't, the court found, if a Rule 29 motion is granted. This is obviously the opposite. In INRE MD, which is a Supreme Court case, those kids were playing doctor with each other. So it was more like, I think the court called it curiosity and exploring, unlike the juvenile in this case who was manipulating these four kids who were family friends and using them to receive sexual gratification and manipulating them with like wanting to play with his Xbox and things like that. So it goes beyond just playful curiosity or anything like that. This is a 17-year-old boy who preyed on kids who were between 6 and I think 12 years younger than him. With respect to the serious youthful offender designation, again, that's subject to an abuse of discretion. And I know that in SD's brief, it says that the court failed to state why it made its findings. But when you read through the record for the July 21st hearing, it's replete with all his reasonings. The court said, I find the resources available in the juvenile system alone are not adequate to protect the court within reasonable expectation. He acknowledged that they had limited time to work with the juvenile, and that was based on what the experts themselves said. And he also looked at the fact that the victims were young children and that there was a pattern of abuse the way that this juvenile was grooming these boys for sexual gratification. So the court clearly used a lot of reason. It wasn't just an off-the-cuff decision. He put in a lot of thought into what was going on. And I think in the brief, they mentioned that the court would maintain jurisdiction under 215283. And my understanding is that jurisdiction only goes as to whether or not he would continue to register as a sexual offender or what tier he would register under. It really doesn't keep control of whether or not he's complying with his treatment or, being able to make sure that he completes the treatment that he and his whole and everyone involved want him to get.
Well, he would have to, under that provision, invoke the juvenile court's jurisdiction to request to be taken off the list, right?
Right.
The juvenile, there's no other thing that the juvenile court can do under that provision.
Right. And so the court's not going to be able to make sure that he's following through with treatment. It's true that this young man wanted and expressed that he did want treatment. He was apparently receiving some kind of treatment, because when he was brought in to talk to the investigator, he said something about talking to his therapist. And so there was some kind of treatment that was happening, but whether or not they had acknowledged the extent of his problems, I'm not sure that they had reached that point until he was accused of these offenses. Unless the court has any other questions, I'll submit on the brief. Thank you.
Attorney Moss.
Thank you, Your Honor. Going back to the third assignment of error, the problem here is that specifically as it applies to SD, this mandatory sentence constituted cruel and unusual punishment. Even though the court was required to look at this youth as a mitigating factor, the fact that it was a mandatory sentence once this SYO determination was imposed took this discretion out of the juvenile court. And so in deciding these appropriate sentences, the court couldn't say what actually was an appropriate sentence for SD. And that's why, just as the same rationale for Patrick, this would violate SD's right to be free from cruel and unusual punishment.
How do you respond to the argument that, sorry, there's like a feedback, the argument that, and I forget which provision this is under, but if he violates, the court has additional discretion to determine whether or not that it would impose the adult sentence?
So even if there was some violation, the court would be stuck with the same situation of having a mandatory sentence because of the nature of the rape charge for a child under the age of 10. So it would be back in the same place.
So there's no discretion if he violates or is not successful with his treatment. Are you saying that the court has absolutely no discretion but to impose the adult sentence at that point?
For the rape charge, yes, there's no other sentence that they can impose. And that's part of why SD had requested the dismissal or reduction of the rape charge in making the Juvenile Rule 29 motion to give other discretion to the court, since that wouldn't be available because of the mandatory nature of the sentence. Now, for the determination of youth as a mitigating factor, it has to be done at sentencing. And Patrick looked at the fact.
I think we lost Judge Zayas.
Oh.
So hold on. We'll give you your time. And maybe Ms. Hayden can try to get her back in. I know you have like a minute left. I'm not even sure. I haven't been. Sorry.
I had about 2.5.
Okay. Okay, she's trying to get her back on. Okay. She should be back on soon. This technology is great when it works. There she is.
All right. So you guys really did lose me that time. As it turned out, my plug was not plugged all the way into the computer. So it died. So Attorney Moss, you were in the middle of your rebuttal argument. Let me see. I mean, I will happily credit you 3 minutes and you can go ahead and continue, or if you want to backtrack a little and then continue.
Thank you, Your Honor. So here, because of the mandatory nature of this sentence, the juvenile court had no other discretion. And because they had to look at, again, youth as a mitigating factor without the ability to do anything with that information, that's why this mandatory sentence violates, or there's no rational basis for the legislator to impose this sentence, because juvenile courts have to look at youth and then are unable to do anything with that information. Now, just in response to a few of the other statements made, so while SD was receiving treatment, it was never specific trauma treatment to talk about the past trauma he had received. Because of a number of other delays he had, he did receive other types of treatment, but it just never was specifically about his sexual abuse or any type of sexual urges he was having. Additionally, the fact that the juvenile court would be able to, he would have to then ask for any kind of declassification through the juvenile court, which would look at how he was doing in treatment. And so even though the court was not specifically going to monitor after he was 21, how he was doing in treatment, if he wanted to be taken off the sex offender classification, then the court would have to look at that at a 0.85 hearing to decide how he is doing in treatment, whether he had been rehabilitated, and whether that classification should end. And so in that way, the court did have the ability to monitor how he was doing after 21 without having to have the SYO designation in place for him. For all these reasons, again, we would ask that the juvenile court's decision be vacated as well as the SYO designation. Thank you.
Thank you both for your arguments this morning. We will
Thank
take the
you.
matter of the submission and issue a timely decision, and have a wonderful afternoon.
Thanks.
Thank you.
Morning.
Good morning, Your Honors.
Good morning.
Good morning, Mr. Ora.
Good morning.
Okay. Welcome to the First District Court of Appeals. We are now here on the matter of Uzi Ora versus Fitness International, case number C200008. Mr. Ora, are you able to hear us?
Yes,
Okay. And you're representing yourself this morning, is that correct?
yes. Good morning.
Good morning. And you are ready to proceed?
Yes, good morning.
Good morning.
I am
So,
representing myself and
okay,
I'm ready to commerce argument.
okay. So you will have 15 minutes to argue, and you can save some of that time for rebuttal. Would you like to reserve or save some of that time for rebuttal?
May it please the court, I wish to reserve 2 minutes of my time for rebuttal.
Okay, well, that then gives you 13 minutes. And you can start whenever you're ready.
My first point, which should cause the court to reverse the decision below, is that for res judicata to apply the prior case and its issues must be actually litigated by the parties. But that did not occur in this matter in the district court because the magistrate gave judgment to LF Fitness because the magistrate alleged that I had not done what she had ordered. And in front of me is the order of Judge Bowman.
You want to speak up maybe a little louder because now we're having difficulty hearing you.
Judge Bowman basically in the order said that I failed. I failed to prosecute and comply with court order. What was happened was that at the date that my second, it was two summary judgment by defendant. One, a motion for summary judgment dated 7/21/2017. Then he moved at the 1/18/2018, and he came with new two summary judgment, which actually was after discovery was closed. So I had no choice other for when there was the due date for the second summary judgment, two summary judgment, I had no choice rather to file 41B(a)(2). And in the hearing prior to that, I requested to reopen discovery and follow with Rule 26, which I was unaware of. So she was denying my request to reopen discovery at the time which the second two summary judgment filed after discovery was closed. Defendant, they said that I replied to summary judgment, it was with respect to the first summary judgment, which I replied to summary judgment and on the alternative for extension of time. So now I will continue. The court did not accept evidence on the subject of the facts in the complaint, and the magistrate ruling did not permit me to reopen.
Mr. Ora, again, now we're starting, because you're speaking down, you need to project your voice so that we can hear you.
So in the meantime, LF Fitness move was, I'm talking about the second summary. I had basically been unable to do discovery because the lack of counsel, and funds, in the hope that the dismissals would be on the merit. So, okay. Without counsel, I was unable to respond LA Fitness motion for dismissal. Judge Hickens, on the other hand, as far as I could tell from the opinion never considered any of this. And to sustain a re judicata motion is required to, according to the United States Supreme to painstakingly examine the record to see if the case was actually litigated. Here, by this, I filed this motion yesterday, order of supplemental authorities. And I will state here, Mansusi v. Stoops, 408 US 204, 1972. Judge Hickens' order claimed that he had examined everything, i.e. the injuries and the docket, but nothing in the records appeared to support this. Judge Barrett's order of dismissal argued that I had no evidence to support my claim based on some argument that involved McDonnell Douglas. This, what he means, is the burden shifting analysis. But I did not have any, at any time have the fair opportunity to present anything in front of a fact finder. My claim in federal court were never litigated. The second reason for reversal is that Judge Hickens didn't have in front of him the complete record for the federal court case, which I complained about on multiple occasions. The discussion in open court and chamber in front of the federal magistrate was part of Judge Hickens. All the records from the federal court was not there, only partial. And therefore, Judge Hickens only had a partial record to examine. The case of Mansusi above could not have been followed by Judge Hickens, and this order of dismissal, which virtually no detail being included, certainly is insufficient to support this decision. As I said, the transcripts was not there. The portion of the unsealed, of the seal, which I unsealed, it was not there as well. And as I said, it didn't have the records from the federal court, from the Court of Appeal, the Sixth Circuits, and from the district court. It should be rather noted that a lay witness pleading failed to include res judicata as a defense in this matter, and no amendment of the defense pleading was ever filed. Finally, the case should be reversed because Judge Barrett's analysis not only denied appellant of due process in that he improvised and invented the whole clause, a case which was not ours, while ignoring rather direct evidence, discrimination, and breach of contract, proceeded to try to act if the case has been actually litigated. And this is the case C. Costa v. Desert Palace Incorporated, 299 F3D 8389 Circuit 2002, and White v. Dennis Incorporated, 918 SOP 1418 District Court of Colorado 19960. Judge Barrett decided the case was not lost by ORA because ORA could not make a prima facie case under McDonnell Douglas without knowing ORA's evidence was. That's it for now.
All right. Thank you.
Good morning, Your Honors.
Morning. Good morning. And let's see if I'm pronouncing this correctly. Is it Attorney Kosker?
It's like Oscar with a K, Kosker.
Kosker. Okay, Attorney
Yes.
Kosker. Good morning.
Good morning.
Whenever you're ready.
Okay, I am Paul Kosker, and I am here representing the appellee Fitness International, doing business as LA Fitness. And I am relying upon my brief upon appeal and its exhibits. I've tried to make the brief as complete and as well documented as possible to explain why the trial court did not err in granting LA Fitness's motion to dismiss, because the federal court did, in fact, dismiss the federal case on its merits. Therefore, res judicata applied. And LA Fitness had filed its answer in the trial court years before the res judicata defense even existed. And therefore, the trial court did not err in granting LA Fitness's motion to dismiss the state case, excuse me. There's absolutely no evidence whatsoever that's been presented that the employee of LA Fitness even knew Mr. Ora's national origin, let alone revoked his membership because of it. And the only evidence offered, and there was a lot of it by way of depositions and affidavits, was that Mr. Ora's membership was revoked solely because of Mr. Ora's unacceptable behavior and conduct in LA Fitness clubs, which is a legitimate and a non-discriminatory reason for revocation. It's not pretextual. Mr. Ora presented only his subjective belief that his membership was revoked, while a white member who he thinks, but he does not know if he was born in the United States, while that white member did not have his membership revoked. However, Mr. Ora does not know who that other person was, the white person. Mr. Ora does not know where the other person was born, and he does not know, and there's been no evidence presented that the other person's membership was not revoked also. In other words, Mr. Ora has only his own subjective perceptions and no actual evidence at all of any discrimination of any kind by LA Fitness. Therefore, the federal court's granting of LA Fitness's motion for summary disposition on the merits, and that's important, on the merits, was correct. And it was supported by the evidence. And it did create a valid res judicata defense. The Ohio trial courts did not err in granting Fitness's motion for summary judgment based upon the proper application of res judicata. The res judicata defense wasn't available or applicable at the time LA Fitness filed its answers years before. Therefore, the dismissals of LA Fitness in the federal court and in the state court were both proper, and there's no valid evidence or valid argument whatsoever that has been raised by Mr. Ora. Accordingly, I respectfully request this court to affirm the rulings of the trial court dismissing this lawsuit against Fitness LLC, doing business as LA Fitness. Thank you.
Thank you, Attorney Kosker. Mr. Ora, you may
Yes.
go ahead with your argument and rebuttal.
Yeah. My complaint back on 7/7/2015 was justified. I've been attacked, and it was a complaint a few days later with Nobus police. And the fact is, this is the complaint, and it's on the docket. The revocation said based of national origin. It was not solely on national origin. The case, it was on the 411202G, not solely on national origin. I'm not, people can look at me, I'm Caucasian, but I'm not white. The other member, he's white. I'm not, but that's the characteristic. My voice, the way I speak English. So it's not just national origin. The member is a lawyer also. He admit the direct evidence. He admit of the day of the incident. After the incident that happened in the locker room, I notify immediately the employee. It's all in the factual fact in docket number 69. He admit, and if this is the case that is all not true, all his affidavit is immaterial, inadmissible, and irrelevant. All his evidence, the docket, 2,000 pages and more, it's irrelevant, including irrelevant, immaterial, or it's false. It's outside the circle. He used a method of inductive reasoning.
Mr. Ora, you have about 30 seconds left.
So they have the opportunity to depose the guy, the employee that was in the that spoke with me and with the other guy, but they went on a detours and come with this ridiculous conclusion that they were trying to present here. I will ask the court respectfully to reverse this decision and sending back to the lower court so I will be able to amend the current complaint and add a more violation. The adding and invading that was in my amendment, second amendment complaint, was never been criticized by the federal court. They are aiding and abetting a white man for convenience. So that's why, and that's why I, among other reasons, justifying reason that when you see the Court of Appeal cannot conduct an appeal without having the whole docket, the all records from the federal court and from Sixth Circuit, or the Sixth Circuit, Federal Sixth Circuit, where there the decision was failing to prosecute. I was unable to write the brief. That's
Mr.
what I
Ora,
think.
if you'd like to wrap up, please.
I respectfully request the court to reverse the decision of Judge Higgins and be litigated back in the common plea. along with and be amended.
Thank you. Thank you both for your arguments this morning. We will definitely take the matter under serious submission and issue a timely decision. And we wish you both a wonderful afternoon.
Thank you.
Thank you.
Good morning.
Morning.
Good morning. Welcome this morning. This is our last case for argument. It's State of Ohio versus James Cheatham, case number 200142. If both attorneys can please identify themselves and their readiness to proceed.
Phil Cummings with the Hamilton County Prosecutor's Office, ready to proceed, Your Honor. Yes.
Thank you.
Will Oswald for Mr. Cheatham, ready to proceed.
Thank you. Attorney Cummings, would you like to reserve time?
I would. I'd like to reserve 10 minutes if I could.
10 minutes, okay. Whenever you're ready.
Very well. Your Honors, I want to put this as succinctly as possible. State versus Stamps. It's cited on page 5 of my brief, and I submit it's dispositive of this case. It was a 1998 decision penned by Judge Painter out of this first district, out of this very court, and it resolves all essential issues that became a problem below. And I say that because Judge Painter makes very clear that in a case like the one we have here, a case where the defense files a motion for a continuance, you don't need to have an entry go on before the expiration of the speedy trial time. You don't have to have an explanation for the reason for the continuance, and you don't have to identify the party that's making the motion. That's all because it's all being done by the defendant. Unfortunately, I believe that appellant Cheatham and the trial court misapprehended that, and they got stuck on the Mincy line of cases, which talks about sua sponte continuances done by the trial court. And in those cases, you do have to file the entry before the expiration of the speedy trial time.
Mr. Cumming.
Yeah.
Looking at State v. Martin, which was a 2019 Supreme Court case, instructs reviewing courts to look at, it says that they must focus on the underlying source of delay. The motion obviously was made by the defense, but the reason for that motion was the criminal rule 16K discovery violation. So what exactly are you arguing is the underlying source of the delay?
Well, I'm arguing that the motion to continue filed by the defendant automatically told the speedy time clock. It was automatically told it.
But it was filed due to the prosecution's discovery violation.
Well, I think I understand your point, Your Honor. I completely understand where you're coming from. I think if that wanted to be pursued by the appellant, he could have made that point to the trial court, and he could have said, "Hey, look, I'm hamstrung here because I got this late report. I need time. It's their fault. I need a continuance, but it should be at the state's request, or it should be a sua sponte continuance." But that didn't happen. I think Mr. Oswald here actually was trying to be proactive and bring everybody together, and I think he arranged for everybody to meet in the trial chambers on the day after he filed his motion for a continuance, and I think everybody agreed to continue the case to February.
But we don't really know because there's no entry. So we know that in his motion to continue, he did argue about, he said the reason for it is the discovery violation, and I got to hire an expert.
Right.
But as far as, normally you do have a document that charges the speedy trial time either to the defendant or to the state. We don't have that here. So going back to Judge Bach's question, don't we under Martin have to just now, because I think Martin seems to me to make pretty clear that there doesn't necessarily need to be a document filed as long as we can tell what the underlying reasoning is. But we do have to look at why this continuance was granted, right? To determine who gets charged the speedy trial time.
Absolutely. And I think that's what Judge Painter instructs the courts to do in his decision. He said, we really need to look beyond the entries and let's read the transcript. Let's find out what really goes on, what went on below. And he said, we ought to decide these issues based on what actually happened. And I think when this court looks at what actually happened, it's clear that they agreed to continue this case to February 18th, and they all agreed to do that. As soon as that meeting was over on the 26th of September, subpoenas were sent out for that new trial date. And I think the circumstances clearly indicate the continuance was granted by the trial court.
Are you saying that the defense's agreement to the new date is sufficient to toll the time regardless of the reasoning for the request of the continuance?
No, I'm saying the defense's filing of the motion to continue itself on September 25th automatically told it. That's all that was necessary. As soon as the defense filed the motion to make that continuance, by the terms of the statute, very clearly, just that is sufficient to stop the speedy time clock from running. The Sims court says that. The Stamps court says that. The statute on speedy trial tolling says that. It's subsection H.
But you also, maybe I misunderstood you. I thought you said that Judge Painter under Stamps had also instructed to look for the reason of the continuance. Did I misunderstand you in that?
Yes, he did not say look at the reason. He said let's look and find out what actually happened below, and let's try to do justice to all the parties and really understand what happened. And it's what his point was. Let's not be willfully ignorant of what happened. Let's not be hung up on something that is claimed not to be there, because clearly the entry did not go on, and that's explained.
Well, Mr. Cumming, speaking of Judge Painter cases, if you look at State v. Ford, that was another case where the state violated the discovery rules. And I realize that the circumstances are much different there. In that case, the state took 67 days to respond to a motion to discovery. In this case, the state was simply late with its expert disclosure and report. But the fact remains that that case was about a discovery violation.
I think in Ford, the defense didn't file a motion for a continuance, though. I think that was a sua sponte continuance by the trial court, wasn't it? If my memory serves. And I think that's Judge Painter.
No, that's in that case, the defendant filed a motion for discovery. Didn't file a motion for continuance, it filed a motion for discovery. And like I said, the circumstances are different, but both were charged to the state due to a discovery violation.
Well, I think that I think it's clear. My point is that what takes Ford out of this completely is there was no motion to continue filed in Ford. Here, there was a motion to continue, and by the terms of the very statute, as soon as that's filed, automatically the speedy time clock is tolled.
Can I ask
Why should it be tolled? Go ahead, Judge Gross. I'm sorry.
I'm just kind of curious on to how this should apply in the future in a situation like this where the state violates the discovery rules, discloses an expert late, which forces the defense to have to ask for a continuance. Are you saying that at that point the defense needs to say to the judge, you cannot charge me with the speedy trial time? This continuance needs to be on the state. They have to specifically state that. And
well, I think it's been long standing that as soon as the defense files a motion to continue, that waives time. The client's bound by that, and the speedy time clock stops. That's just been the law ever since I've been around, is as soon as they file a motion to continue, that tolls the speedy time. You don't need a follow-up entry, and you don't need to explain why in an entry. Everybody understands why, because it's in the defendant's motion to continue, like it is here. I need more time. I need to get an expert. We know the party to charge it against because it was filed by the defendant. And that's why Judge Painter says that's what makes these cases different. When you have a motion to continue filed by the defendant, it automatically tolls the time, and you don't have to worry about the speedy trial clock and getting the entry in within the 90 days. It's a different character case, and that's the key here.
Thank you. I'll reserve your time.
Thank you.
Attorney Oswald, good morning again.
You're muted. You're muted.
Sorry. Thank you. With regard to Mr. Cummings' argument, I think what he's arguing, and he put this in his brief, is the motion for continuance is still pending, and therefore the time has been told. I think it's pretty clear here that Judge Foley granted the continuance. I mean, we can see that that on the motion that was filed for the continuance on September 25th, he then put on an entry granting, appointing an expert on September 27th. And I don't think there's any dispute that the case was continued to February, even though there's no entry. So I don't think that the continuance was actually pending at that point. I think he ruled on that. And as of September 30th, that trial date, he granted the continuance. So I don't think that the continuance is pending and time is being told. The next step is, even if the defense asks for a continuance, the next question is, who is time waived or who does it get charged against? But you can ask for a continuance, the court can grant it. That doesn't necessarily mean it's on the defendant. And unless they waive time, it does go against the state. And in this case, 10 days before trial, when Mr. Cheatham's been locked up for nearly 20 months, we get this expert report. And to Judge Krause's question, if this is permitted in the future, anytime prior to 21 days before trial, the state now can file an expert report. And then if I waive that time, you guys recently made a decision that I'm ineffective if I do waive that time to go ahead and go to trial unprepared with an expert, or I have to file a continuance, and then the state's arguing, well, it's your request that tolls time. So it's an unfair advantage to get ambushed with an expert report and then say I have to waive time. Ultimately, it's very clear the time has to be waived on the record or in writing. It never was. So whether or not the continuance was my request, it doesn't resolve the time issue in who's it going to be charged against. There's no question there was a discovery violation. And the fact that Mr. Cummings cites two stamps, Painter's own language that says, the journal entry should not allow defendant to use the speedy trial statute as a sword rather than a shield it was designed to be against. If anything, the defendant's using this as a shield. The state used it as a sword when they had the discovery violation. So this isn't a game Mr. Cheatham played where he requests the continuance, there's no entry, and then he raises the speedy trial issue. This is all because of the state 10 days before trial filed the expert opinion. So again, I mean, I think that I studied Ford in my brief. I absolutely think it was a discovery violation. It puts the defense in a very difficult position if they're going to have to waive time every time this happens. And I think the time should go against the state. I think Judge Foley appropriately dismissed the case because of violation and the speedy time. And there is no entry or anything on the record to show that Mr. Cheatham waived the time. So for those reasons, I'm asking you to affirm the trial court.
Thank you. If there's nothing further from the panel, thank you. Attorney Cummings? You're muted.
Sorry about that.
No worries.
Basically, I understand everybody's concern about the discovery and the late provision of reports. I get it. I think, though, that the way to handle that is you have a meeting like Mr. Oswald did with the court, and you say, look, I'm jammed here. I need time, but it should be charged against the state. That becomes something that's negotiated or discussed. But you can't, the statute itself by its own terms says the period of speedy trial time is told by the period of any continuance granted on the accused's own motion. So if this court ignores the rule, I don't understand the basis for doing that or the precedent for doing that. Because I think this court still has its own precedent, which says these types of cases, when the defense makes a motion to continue, he waives time. That's been the law for, as long as I've been around, actually. The defendant is bound by that waiver. It's effective on the time and the date that the counsel files the motion to continue. You don't have to wait for an entry to go on. It's effective as soon as it's filed. That is the way the law has been, and I'm not sure exactly how you can look behind it when the defense files a motion to continue. It's clearly chargeable to the defendant in those circumstances. If there's going to be
put a defendant in a catch-22, I mean, as Mr. Oswald was saying, either he goes to trial without an expert or time is charged against him due to the motion to continue.
Well, not at all. I mean, like I said, he, instead of filing a motion to continue, he could file a motion to have a conference and say, look, I'm strung up here. There's been a discovery violation. I need some relief. And there's other avenues to pursue without filing a motion to continue. I do think the court has to retain basic bold letter law, which is once the defense files a motion to continue, the time is told. To address these types of issues, I do think it's incumbent upon defense counsel or the courts to negotiate, the penalties for a discovery violation.
What motion could the defense file besides a motion to continue that wouldn't stop the clock?
Well, he could file a motion for a declaration of a discovery violation and a hearing on that and say, look.
So that doesn't stop the clock?
It could, but I also think it's not as clear. I think certainly it's Hornbook law that if you file a motion to continue and the defense files it, time is told, game over. I understand the court's concern about discovery issues, but it has to be handled in a way such that they're not filing a motion to continue, because as soon as they do, the case law has been very clear for decades that tolls time. It's right out of the statute. It's right out of all other case law. I think that those issues can and should be addressed, but I think maybe in terms of a discovery violation, a sanction for that, pursue a continuance at the court's own order, or charge it to the state if it's an egregious violation of a discovery. Absolutely. I don't think.
Do you think under these circumstances that the time should have been charged to the state based on the fact that they didn't turn over their expert until 10 days before trial?
No, the defense filed a motion to continue. That's as far as the court need look. That automatically told the time.
So what should the defense lawyer have done in this case? I mean,
maybe file a sanction for a discovery violation and say, look, this was a late report. I don't have time. I need more time, but don't charge it against me. It's not my fault. I certainly understand where the defense is coming from. They have absolute right to complain. I think they just have to understand, though, that there's ways to address that. And if you choose to file a motion to continue, you've bound your client to that. And they are bound by that under State versus McBreen, I believe. It's an Ohio Supreme Court case. Once the counsel files a motion to continue, the client's bound by that. Time is told. Time is waived. I'm sorry if that's a frustrating answer, but I think that's going to be the state's position on this type of scenario where the defense files a motion to continue. It's just that straightforward. I have nothing else unless the court has any further questions.
Thank you. Thank you. Thank you both for your arguments this morning.
Thank you.
Thank you.
Thank you. We're going to take the matter into submission and issue a timely decision, and I hope you both have a wonderful afternoon.
Thank you. You too.